Welcome to Virtual Office Hours, How to Excel on Law School Exams, sponsored by the American Bar Association and JD Advising. The Virtual Office Hours series connects you with experts to help you thrive as a law student and prepare for life after law school. We're really excited today to have Heather Buck with us to provide tips to help prepare you for and take law school exams. Heather graduated cum laude in the top 10% of her class at Wayne State University Law School. She received numerous scholarships and awards at Wayne and has passed the Michigan and California bar exams. After law school, Heather spent about 3 years clerking for various judges at the 3rd Judicial Circuit of Michigan. Heather teaches JD's Advising's Michigan bar exam, uniform bar exam, and California bar exam courses. She also tutors private students for bar exam, all first-year law school classes, and the MPRE. Hannah McNeese is also here with us to answer questions throughout the program. Hannah is a licensed attorney and used JD Advising to pass the bar exam. She worked in family law for 10 years before coming to work for JD Advising, where she now helps students in finding the best fit for them, whether it's pre-law, law school, or bar prep programs. Heather, we'll turn things over to you now.
Thank you so much. And thank you guys for coming today. I really appreciate giving me the time to share some tips and tricks with you. Throughout the program, if you have any questions, feel free to submit them through the Q&A function in Zoom. As Tracy said, Hannah will be answering questions periodically, and she may also save some of the questions for me to come back to and answer at the end. So if she sees anything that is kind of like a common question, just try to be patient when you're waiting for an answer, because it's possible that I will come to it at the end and answer that question. I am going to cover some substance that can be found in a handout. If you don't already have the handout, you should be able to find a link to the handout in the chat box if you'd like to download it and follow along. But I will share the screen, as you can see here. And so the information I'm going to cover will be on this PowerPoint that I'm going to go through. So if you don't have the handout in front of you, that's okay. You'll still be able to follow along. So we're going to talk a little bit today about how to excel on law school exams. And the reason we're talking about this, and we're going to spend so much time focusing on this one part of law school, your exam, is because success in law school is based on your success on law school exams. So if you're in your first year of law school, I know this is probably becoming evident as the semester is probably wrapping up at this point. I can't believe we're already into November. But your entire grade usually in your class is based on one final exam. So you want to make sure you're taking that exam seriously, doing your best on it, and putting all of your effort into it to make sure you get as good a grade as possible on that exam, given that that dictates what your grade will be for that class. So we're going to talk today about how to excel on that law school exam. As I just said, in general, you have one exam per class that dictates your entire grade for that class, making that exam really important. So it can be really stressful, but I will share some tips with you today for how to tackle exams to maybe hopefully reduce some of that stress. It's important to remember that law school exams test your ability to think critically and apply the law to fact patterns. So this is different from exams you probably took in undergrad, where professors are just testing your ability to spit back the information that they gave you throughout the semester. Law school exams are a little bit different. It's not enough to just know what the rules are. You also need to be able to apply those rules to different fact patterns, and we'll talk about how to do that. Law school exams are also typically graded on a strict curve. The curve is usually the most strict in your first year of law school. Some law schools follow a curve throughout all 3 years. Some have a different curve for the first year compared to the second and third year. And when they do that, the first year curve is usually the most strict. I've had so many students trying to figure out what the curve is if their school doesn't tell you the curve. And honestly, it's not really worth trying to game the system to figure out how to beat the curve. But I will tell you that with the curve in mind, you should remember that you're kind of competing against everyone else in your class. So it's not necessarily about writing a perfect answer. It's about making your answer better than the person sitting next to you so that you fall a little bit higher on that curve than they do. So I'm going to use this fact pattern as an example. I'm going to walk through it with you a few different ways to show you how to answer law school exams. This is a torts question, and as a kind of a heads up, it has to do with negligence. So I'll read it. It says, Dan, a dog breeder, had some 8-week-old puppies to sell. Bob and Carol went to his house to look at them. Dan invited them into the living room where the puppies were located, and he said, whatever you do, don't go into the room at the end of the hall. As they were examining the puppies, the largest puppy, without warning, gave Carol a nasty bite on her hand. Dan told Bob to go to the bathroom near the end of the hall to retrieve some bandages. Forgetting Dan's earlier admonition, Bob opened the door at the end of the hall, thinking it was the bathroom, and entered a darkened room where Dan kept an enormous pet chimpanzee. The chimpanzee jumped between Bob and the door, beat its chest, and made menacing hoots. Frightened, Bob stood still. In attending to Carol's bite, Dan mistakenly grabbed a bottle of heavy-duty solvent, thinking it was a bottle of antiseptic. When Dan rubbed its contents into Carol's wound, she began to scream and shout in pain. Hearing Carol's cries, Bob barged past the chimpanzee, which gave him a deep gash to his head as he passed. Shaken and sore from their injuries, Bob and Carol fled Dan's house. Number 1, what claims may Carol reasonably raise against Dan? What arguments may Dan reasonably make? And what is the likely outcome? Discuss. And number 2, what claims may Bob reasonably raise against Dan? What arguments can Dan reasonably make? And what is the likely outcome? And discuss. So we're going to use the IRAC formula to answer this question. And IRAC stands for Issue, Rule, Analysis, Conclusion. Now, I've had many people tell me that their professors have said, I don't like IRAC. I don't want you to get too focused on IRAC. Don't worry about using IRAC. Now, this could mean one of two things. Number 1, some professors like some variation of IRAC. So for instance, they may like CRAC, CRAC, which stands for Conclusion, Rule, Analysis, Conclusion, or they may like CREAC, CREAC, which stands for Conclusion, Rule, Explanation of the Rule, Analysis, and Conclusion. So if your professor has indicated a preference for a different version of IRAC, you can easily twist what I'm about to tell you with regard to IRAC to fit that professor's preferences. The other kind of reason professors say they don't like IRAC is because it's a little too simplistic sometimes, and you might miss things if you're sticking to a really straightforward IRAC. And what I'm going to show you is a more complex version of IRAC that I think satisfies that problem and will allow you to give your professor everything they're looking for in a more detailed manner than really this very straightforward IRAC. But regardless of what form of IRAC you're using, a simple IRAC, a complex IRAC, CREAC, CRAC, the key is that it's very formulaic. This is really about just filling in the blanks. So a lot of people may sit down to an exam and think to themselves, I just need to start writing something because I need to get going. I'm under time pressure here. Rather than just word vomiting on the page, start by remembering this formula so that you can fill in the different pieces of the formula. It's going to give you a good place to start as you're writing your exam. So the first part of IRAC is the issue statement. So we need to go through and spot the issues. And this is going to come from a careful reading of the facts. So you want to make sure that you are paying close attention to the facts as you read the fact pattern to try to pull out all of the issues. Every sentence in the fact pattern is most likely there for a reason. So I'm going to show you what this looks like using mostly this first question. We're going to focus on what claims Carol can reasonably raise against Dan. So Carol went to Dan's house. She's looking to buy a puppy, and the largest puppy gave her a bite on her hand. Also, she had that second injury when Dan grabbed the bottle of heavy-duty solvent, thinking it was antiseptic. He poured it on her wound, and now she's screaming and shouting in pain. So Carol, from these facts, has 2 injuries, the puppy bite and the heavy-duty solvent injury. So we're going to discuss those 2 different causes of action that Carol could raise against Dan. So you can see here, I've kind of gone through and made a list of the issues that this fact pattern raises. So for Carol, we have negligence for the dog bite and then negligence for the solvent injury. And then there are some sub issues here that this fact pattern raises that we should address. So she was at Dan's house to buy a puppy. So Dan is the premises possessor, which creates a sub issue of premises liability. This could change the duty that Dan owes with regard to the negligence for the dog bite. Also, we may have a duty with regard to domestic animals that we should probably also discuss with regard to the dog bite. With regard to the solvent injury, Dan was attempting to rescue Carol from her dog bite injury. So we can talk about this in terms of the duty to rescue or the duty owed by a rescuer. The other part of the question also asked us to talk about Dan's arguments that he could raise in response. So Dan is the defendant here. So what is he going to argue? The defenses to negligence, because both of Carol's claims here are for negligence. So he could argue things like Carol assumed the risk, Carol was comparatively negligent, or Carol was contributorily negligent. Same thing for Dan. He had that injury from the chimpanzee. So you would want to go through and list the potential causes of action, any sub issues you see from that cause of action, and then defenses that Dan would raise in response. So these are the issues that we have to work with from this fact pattern. The next part we have to do is fill in the rule. So we did the I of our IRAC. So now we're going to move on to the R, which is for the rule. And just a couple tips when it comes to stating the rules. The very first thing, this isn't in this slide, but I do want to mention that people tend to get too focused on the rules, thinking that this is the most important part of the exam. And it's usually not. So many law school exams are open note, open book. And so your professor knows when it comes time to state the rule, if you have your notes next to you, you're just going to open your notes and you're going to copy the rule down. So they kind of expect a really good rule statement, but aren't going to give you a ton of points for properly stating the rule because they know you're just able to look it up during the exam. That being said, you do want to make sure you state the rule correctly because it looks pretty bad if you have the ability to look it up and you incorrectly state the rule. Also, because this probably isn't worth a ton of points, you want to try to get through this portion of the exam quickly. The analysis portion is where you're really going to pick up your points. So you don't want to spend a ton of time trying to come up with rule statements. So if you don't have to look it up because you have it memorized and you know these rules really well, that's going to make this portion of the exam go quicker and let you get to the part that is going to get you the points, which is your analysis. So to quickly get through this portion of the exam in as efficient a manner as possible, first of all, you should make your own outlines for law school. If you don't have time to make your own outlines, and even if you haven't started them yet, there is still plenty of time in the semester to make your own outlines. Try to find someone who took that class with that same professor, like a 2L or a 3L who had that class last year, and use their outline. The reason you want to do this is because you want to try to learn the material the way your professor presented it. And so your notes or that other student's notes and outline are going to have the information the way your professor wanted you to learn it. That way you can use that outline to spit it back out in your exam the way the professor had taught it, which is what they're looking for when they grade these. So you don't necessarily want to use a commercial outline as your sole outline because it's not going to be tailored enough to your class. It's going to be a little bit too generic. If you do have to take someone else's outline, try to personalize it, reorganize it, color code it, make sure you go back through it, enter some notes, move things around if you don't have time to make your own. But making your own is by far the best method to learn this material well and quickly. After you make your outline, you should take some time to actively review it. A lot of people make the mistake of waiting until like the end of classes to start making their outlines. If you haven't started your outlines, start them now. What you want is to have some time between finishing your outline and the exam to be able to actively review your outline. This is where that memorization comes in, where your understanding of the rules will come in. And this is what's going to let you answer that rule portion of the IRAC really quickly and move on to the things that will get you more points. So there's some suggestions in your handout for how you can actively review your outline. But active review is more than just reading your outline. Don't just sit down with your outline and read it front to back and say, okay, I reviewed, I'm good to go. do something to actively work with the material to make sure it's going to stick with you and that you know it really well. As you're reviewing, you should really go through your outline one small section at a time. So if your outline is 50 pages, don't sit down and say, I'm going to read all 50 pages. None of that is going to stick with you. It's going to be so overwhelming, and that's so much information that you're flooding your brain with that it's really not a good use of your time unless you have the world's best photographic memory. So if you don't, you want to make sure you're breaking this outline up into small chunks. So if you're reviewing your torts outline, for instance, just review the section on duty. So sit down and review the duty portion of negligence a few times. Maybe you go through it 3 or 4 times. And then once you feel comfortable with that portion, then move on to the next section and start looking at like the breach part of negligence. This is going to make it much less overwhelming and way more likely that the information actually sticks with you. As you're reviewing, make sure you're taking breaks. If you are reviewing with the TV on, or you're reviewing your outline while you're doing something else, you're not putting enough effort into reviewing your outline. That's why I said it's important to be actively reviewing your outline and not just kind of like passively reading it or passively listening to someone else read it to you. Make sure you're really working with the information, but that is exhausting. So you don't want to sit down and force yourself to go through this information for 5 or 6 hours at a time. Take breaks as you're going over this information. It's more likely to stick with you if you take this information in smaller chunks and give yourself a chance to digest it. Finally, make sure you understand the material as you're reviewing it. If you're reading your outline and you're like, I don't know what that means, but that's okay. If it comes up on the exam, I'll just flip to my outline and I'll copy it down. You're probably going to be okay on the rule portion of your IRAC, but it's going to be a problem when it comes to the analysis. Because if you don't really understand it, you're not going to be able to apply it to the facts of the case in your fact pattern. So make sure you do understand what's going on. And if you're struggling to understand it, think about finding a friend to study with, a study group, see if someone else can explain it to you. Google it. I do this all the time. Just Google it and see if someone can explain it in different words that makes it a little bit clearer. Or if it's within your budget, consider hiring a tutor. Look into getting a tutoring service and work with a tutor to help understand the material. Just being able to spit out the material is really not going to get you very far on the exams. You have to make sure you understand it, like I said, so that you can apply it to the facts. As you're reviewing, make sure you're focusing on what matters, and what matters is what your professor focused on in class. So this goes back to what I said before about using an outline from someone who took that class with that professor. If you don't have time to make your own, your professor is going to spend more time on the stuff that they think is more important. So they spent 2 class periods talking about a single case. You probably should know how that case works, what the rule is, and how to apply it to facts of a slightly different case. But if they breeze through something like a quick note at the end of the case, or if they don't really focus too much on the facts of the cases, they're more interested in the holding or the takeaway from the case. Those are the things you want to focus on. So focus on the things that are going to get you the points. Don't worry about the little details that you're probably not going to use on the exam anyway. Make sure you're giving yourself a chance to keep coming back to your outlines. You want to review them a couple times. You don't want to just look at it once and say, okay, I'm good. I looked at it. I'm done. I'm good to go. Make sure you're regularly reviewing them and actively reviewing, because every time you review them, you might have something new to add or something new that clicks, something new that you understand that last time you reviewed it didn't quite stick with you. So give yourself the time and a chance to keep coming back to your outlines as you're studying for your exams. Okay, so now that we have our tips on how to figure out what the rules are, we're going to go back to that fact pattern and we're going to talk about the rules that fact pattern raised. And we're mostly going to focus on Carol's first claim, the negligence claim with regard to the dog bite. So we need to start with our general rule for negligence, in which says, in order to make out a prima facie case of negligence, the plaintiff has to show duty, breach, causation, and harm, actual and proximate cause. So what we're going to do is we're going to break that down and we're going to talk about each element individually, because that rule statement on its own it doesn't encompass a lot of the detail that we need with regard to negligence. So we're going to take this one element at a time, and we're going to start by talking about duty. So within duty, we're now going to bring up all of the relevant rules that apply to the duty that Dan owed to Carol. So here we have an individual generally owes a duty to others to act as a reasonably prudent person would under similar circumstances. That's our general rule for duty. The majority view from Cardozo is that a duty is owed to foreseeable plaintiffs who are in the zone of danger. The minority approach, which comes from Andrews, is that a duty is owed to everyone, including unforeseeable plaintiffs. In determining what is reasonable, courts will look at things like physical characteristics, age, expertise, and whether the situation is an emergency. We also talked about the fact that Carol was at Dan's house to buy a puppy, making her an invitee of Dan's property. So we also need to talk here about how that invitee status could affect Dan's duty. So that the next paragraph says a specific duty is owed by owners or occupiers of land, depending on the status of the plaintiff. If the plaintiff is an invitee, so someone who's on the premises for a commercial purpose, the premises possessor must warn or make safe all dangers that he knows or should know of. So within the duty sub rule, there's really three different pieces that we're going to need to look at when we analyze the facts. Number one is the majority minority approach. So whether Carol was a foreseeable plaintiff or not. Number two is that general duty. So whether or not Dan acted as a reasonably prudent person. And then number three is the invitee status. Does this change the duty that Dan owed to Carol because she might have been an invitee, given that she was possibly there for a commercial purpose? She was there to potentially buy a puppy from him. So we have all the different parts of the duty combined into this rule statement. We can go on and do the same thing for the other elements, state the rule for breach, state the rule for actual cause, state the rule for proximate cause, state the rule for damages. And then what we're going to do is we're going to move into the analysis. So as I said before, this is the most important part of your law school exam answer. This is where your points are coming from. So when you're using IRAC, this is what a simple IRAC would look like. You state the issue, then the rule, then the analysis, and then the conclusion. This is probably a little bit too simple to get a really high score on your law school exam. If we were using this simple IRAC to answer this question about Dan's negligence for the dog bite, we would say the issue is whether Dan's negligent. The rule is negligence is duty, breach, causation, and harm. And then your analysis would look something like Dan had a duty, Dan breached that duty, Dan's breach was the cause of Carol's injury, and therefore Carol has harm because she was bit by the puppy. You want a little bit more detail than that, but your analysis would basically mush all of that information together into one paragraph, and then you would conclude, therefore Dan was negligent. So in order to get a better score on your law school exam, that's where we have these more complicated IRACs that we need to break down the information into a little bit more organization. So this middle one is actually the structure that I used and to show you those different issues and the rules for the fact pattern. So this is a version of a more complicated IRAC you could use. So we started with the overall issue, which was negligence. The rule, that was where we stated the elements of negligence. And then in the analysis, we have mini IRACs for the different rules, or I'm sorry, the different elements of negligence. So we're going to have a mini IRAC for duty, mini IRAC for breach, mini IRAC for proximate cause, mini IRAC for actual cause, and a mini IRAC for damages. So rather than just saying he had a duty, he breached it, that gives us the opportunity in this mini IRAC here to go through all of those extra pieces of what exactly his duty was, like we just talked about. The foreseeable plaintiff, the invitee status, the reasonable person standard. We can use the mini IRACs to kind of build out those sub issues that we have within the overall larger issue, which is negligence. Now, this may not work for everything. You may have issues that are slightly more complicated that require an even more complex IRAC structure. So you can see at the bottom, there's a different version of what it could look like. Within that mini IRAC, you might need a sub mini IRAC to explain some other piece of the law. And that's okay. I would recommend using headings to identify what part of your analysis or what part of your answer you're in. So within this version, I would have a heading for duty, a heading for breach, a heading for proximate cause, and so on and so on. That way your professor can kind of see where you're at, they know where you're going, and it makes it easier for them to read your answer. The easier you make it on them, the more points they're likely to give you. So try to keep your answer clean and straightforward and organized, because that's what's going to get you a lot of points. So within the analysis for each of those sub issues, what you want to do is try to raise arguments that both sides will make. So with regard to duty, for instance, we talked about those different pieces, and I'm going to back up a second and go back to that duty rule. You're going to want to talk about what Carol will argue and then what Dan will argue for each of the different parts of the duty rule. So Dan is going to argue he acted reasonably. Carol, on the other hand, will argue that he didn't act reasonably because maybe he should have warned her. He should have done something to tell her, hey, don't touch that puppy, it's likely to bite you. With regard to the majority minority approach, Carol's going to argue she's a foreseeable plaintiff. She's in Dan's house. Dan might argue she's not foreseeable. He didn't know she was going to touch the puppy or put her hands near the puppy's mouth. So we want to make sure we're addressing arguments from both parties' sides in our analysis section. So that's going to go within this A right here. So we're working on this duty mini IRAC. Within this A, we're going to talk about what Dan will argue and what Carol will argue for each part of the rule that we're analyzing. That is what is going to get you the maximum amount of points on your exam. Don't automatically assume that you're representing one party or that one party is correct. You want to try to address both parties' issues or arguments, and then ultimately conclude and indicate who has the stronger argument. So for instance, with regard to whether or not Carol is a foreseeable plaintiff, Carol's going to say, yes, I'm foreseeable. I'm in your house. Dan's going to say, no, you're not foreseeable. I didn't know you were going to do that. Someone being in your house makes it foreseeable that they could be injured by something in your house. So Carol has a much stronger argument here that she is a foreseeable plaintiff. So with this first portion, I would therefore conclude that Carol has a stronger argument. She's likely foreseeable. So Dan does owe her a duty for that reason. Then we need to go on and talk about those other parts of the rule that we talked about. Like I said, the reasonable person standard and the invitee status. As you are studying, you should really try to do some practice exams. And as you are using practice exams, the best practice exams are the ones that have model answers. So rather than just doing a practice question, reading your answer, going, that was okay, hopefully I do better next time, and maybe tossing it in the garbage, think about how your answer compares to the sample answer or model answer that you have. And there's some questions listed for you that you can ask here when comparing your answer to the model answer. This is how you're going to improve your score. Make sure that you're doing the same things that the model answer is doing. And if you're not, take note of it. You want to kind of work these kinks out as you're going through practice exams, rather than having your actual final exam be the first time to kind of try this method, so that you can get the most points possible. Get the issues out of your system with the practice exams, figure out what the problems are by comparing your answer to the model answer, then you're much more likely to get a really high score on your final exam. A few last minute tips for writing essay exams. Make sure you analyze the issues, but don't worry too much about the obvious ones. So for example, if you had a contracts question and it tells you at the beginning of the fact pattern, Bob and Joe entered into a valid contract. And then the question ultimately asks about what remedies Bob could recover because Joe breached the contract. You don't need to spend 3 paragraphs talking about contract formation. They told you that they have a valid contract, and the question is focusing on remedies. So even though, yes, there are some facts to discuss contract formation, you're not going to get many points out of it. So try not to waste time talking about those super obvious issues. Try to focus on more of the nuances, because that's where your answer is going to stick out compared to the person sitting next to you. And remember, with the curve, that's kind of the goal. Second, make sure you state the relevant rules of law, but don't just dump everything you know into your answer. So when we were talking about that fact pattern with Dan and Carol, we talked about the duty rules that are relevant to these facts. We didn't, for instance, go on and on about the duty owed by professionals and the duty owed for children, because those aren't relevant here. So we don't want to outline dump everything we know into our answer. Try to stick to what is the most important. Third, make sure you use the facts to support your arguments, but don't just restate or summarize the facts. This is a very, very common mistake that I see people make, is that they waste time summarizing the facts. So with that question we looked at, for example, what you don't want to do is start your analysis by saying, in this case, Carol went over to Dan's house to look at some puppies. She was thinking about buying one, and one of the puppies bit her. You are going to get a total of 0 points for that sentence, because all you're doing is copying down what the fact pattern already told you. So the professor doesn't really care that you're able to read and copy the facts. That is a complete waste of time. Instead, stick with the law. Go straight into the law. So if your analysis is about whether there's a duty, you want to dive into the law with regard to whether Dan owes Carol a duty and pull in the relevant facts. So you may say, Dan owes Carol a duty because she was at her house to buy some at his house to buy some puppies. So you're showing that the facts apply to the law that you're currently discussing. You don't need to just restate what happened with the facts. Finally, use the facts to support your arguments, but don't make up new facts and discuss the facts that you made up. Try to stick with the facts that you have. If you start making up new facts, the professor sees that as you don't know how to answer the question that they actually asked, and now you're trying to change the question to answer what you want to answer, and that's not the assignment. So try not to make the facts up. Try not to make up facts, but certainly you want to point out anything that would be helpful that you don't know. Like here, for instance, we don't know if this puppy ever bit someone else before. That would be helpful to know, because if this puppy had bit someone else, then that makes it more likely that Dan should have warned Carol, hey, that one bites, don't put your hands near it. So we could point that out, but we shouldn't just make things up to change the fact pattern. If your professor includes multiple choice questions, there's some tips in your handout for what to do with multiple choice questions, how to tackle them. My biggest suggestion is to get your hands on some practice questions. So there's some suggestions here for where you can find practice multiple choice questions. You can Google search. Multiple choice questions are on the bar exam. So bar exam supplements are going to have multiple choice questions you could use to practice. JD Advising has a law school study aids program that has multiple choice questions. Just try to get some practice multiple choice in is my biggest tip. Same thing if your professor includes short answer questions, which is on this next slide. Try to use some short answer questions to practice. A great resource for short answer questions is Glannon's Examples and Explanations supplements. At the end of each chapter, they have some short scenarios that are like short answer questions. So if you haven't already, figure out what the format of your final exam will look like. Ask your professor, is it long essays? Is it multiple choice? Is it short answer? And get your hands on whatever type of question you should expect to see on your exam so that you can do some practice. And like I said before, kind of work out the kinks in your exam taking strategy so that you are ready to go and you know exactly what to expect when it comes time for the exam. I want to briefly turn things over to Hannah just to introduce herself, tell you a little bit about JD Advising, and then if any of you have questions, please still feel free to submit them through the Q&A and we'll be sure to take them at the end.
Thanks, Heather. Hi, everybody. My name is Hannah McNeese, and I am the account executive here for JD Advising. I'm a licensed attorney in the state of Michigan, and truly a personal testament to how fantastic JD Advising's materials are as I've used them myself. So before we turn things over to a Q&A briefly, I did just want to touch on a few things that we can offer you here at JD Advising. You will also find a description of these towards the end of your handout as well, with links to click on that associate them back to our website. So one of the first things, and I think Heather briefly touched on this already, is our law school study aids. They come with outlines, flashcards, multiple choice questions, and really just strategies to help maximize doing well in law school and performing well on exams. We also offer one-on-one private tutoring sessions. They're completely personalized to each individual student based on their needs and their availability. We do law school, bar exam, and MPRE tutoring. We have a couple free resources too. One of them is a free How to Succeed in Law School guide. We have various other guides, blogs, webinars like this very regularly, and videos. We do have a monthly newsletter that goes out as well that you can sign up for. If you are kind of 2L, 3L status and you're looking towards taking the MPRE, we have a free MPRE course. You can sign up for that right on our website. And I think Tracy mentioned we have a couple 3Ls in here that might be thinking about bar exam prep. We have full bar exam prep as well. We have a couple sales going on right now for those prices you can find at the end of your handout. And just lastly, being an ABA student, we do have discounts for you. It's $100 off a bar exam course, $50 off of tutoring services, free law school one sheets, and then a 10% discount off of supplemental products. So if you're interested in any of those, you can shoot us an email at info@jdadvising.com, and we will make sure that you guys get the appropriate discount for those products. Our contact information is on the screen in front of you right now. We have a phone number and an email address. Feel free to utilize either one of those. You'll probably get me on the other end, and I would love to chat with any of you to help you in any way we can. So at this point, I'm going to turn it back over to Heather to wrap up with our Q&A. Please let us know if you have any questions at all.
Thanks, Hannah. So it looks like we had a couple questions in the Q&A that I just want to touch on. I saw a question with regard to actively reviewing your outlines and a couple examples. So what worked for me is actually making lists. I'm a big fan of numbered lists because if I can see how many items are on a list, I'm more likely to remember like that number, and then I'm going to try to hopefully remember the items on the list. So like if I had a rule where I'm trying to memorize 5 elements, I would list them out in elements and I would write that list over and over and over, or do something like write out the list and then cover it up, see if I could say it out loud from memory, uncover it, see if I got all 5 elements, cover it up, try and do it again. Another thing you could do is make mnemonics. So if you find mnemonics helpful, some sort of acronym to remember those 5 items on the list, that's another way to actively review. If you're a visual learner, making charts or graphs or diagrams. When I was in real property, I always found it helpful to draw a little picture for the different cases and the different rules to kind of figure out what was going on in those different fact patterns. That's what I mean by actively reviewing the material, is you're not just sitting and reading it, but you're reading with a pen in your hand, a highlighter, a notebook, so you can kind of work through this information and you're not just trying to let it soak in as you just read through it. One of the other questions said, this was with regard to my example for contracts. I mentioned how if they tell you in the fact pattern that you have a valid contract, you don't need to spend a ton of time going over contract formation. So this question says, would I still briefly cover contract formation, even though the question is geared toward remedies? You can. I probably would quickly mention contract formation, taking not more than like 2 to 3 sentences. So a sentence to say a valid contract requires offer acceptance and consideration. Another sentence to say, in this case, we had an offer acceptance and consideration because we had a valid contract. Therefore, this is a validly formed contract. Literally 2 sentences just to cover your bases with that issue, but you don't want to spend a ton of time there because like I said, it's not going to generate too many points. All right, looked like Hannah was answering that last question. Were there any other questions? So this one says, if a professor doesn't like headings, how would you structure an answer? I would structure it kind of the same way using IRAC. I feel like if they don't want headings, the IRAC becomes even more important so that you make sure you stay organized with the different ideas and they can follow you from one thought to the next. Just don't include the headings. You could just move with transition sentences to the different portions of the IRAC. Any other questions?
Doesn't look like we have additional questions right now, but we want to thank everyone for joining us today, and a special thank you to Heather, Hannah, and JD Advising. We hope you join us for upcoming virtual office hours programming, including March 24th's 8 essential tips for first-time bar exam takers. Visit the ABA for lawstudents.com website for the full lineup of registration. Take care, everyone.